Okay, so we're going to get started with the next presentation. I'm excited to introduce Kelly Manette. I've known Kelly for a long time, and one of the things on her bio says she's been fighting for clients' rights for her entire career, and I can attest that I've seen her do that in court. She is a board-certified specialist in both criminal and juvenile delinquency law. In 2012 and 2014, she taught at the Community Juvenile Justice Clinic, and she handles cases all across the juvenile level and security.
Good afternoon. I'm going to move over here because I walk a little bit and I don't want to block the screen. Can everybody hear me okay? I know we're having some issues. All right. Am I echoing at all?
Nope.
All right, great. So I'm talking about preservation today, and I know that Yolanda just read a little bit about my background, but I want you to know I am first and foremost a trial attorney. And starting 4 or 5 years ago, I started handling appeals as well. But I understand the trial lawyer's quandary about preservation of the record, which is sometimes you have to make that choice between properly preserving an issue or potentially harming our case by doing so, right? Our chances of trial. And we have to think about these things strategically. So part of what I want to do today in my presentation is talk about the specifics of preserving juvenile matters for appeal, but how to wrap and incorporate them in so that they're not harming your overall trial strategy. How many people in this room have tried a murder case for an underage person in Superior Court? Just a couple so far. And when you did those trials, how many of them were, my client didn't do it at all? Was that the defense? Neither one. That's fantastic because that makes this a little easier. But when you have that case where it's my client didn't do it, you're going to have a little bit of a quandary of how to deal with all of these juvenile related matters when that's not the focus. When you've got a first degree murder case where your argument is my client didn't premeditate and deliberate, my client did, those things merge a little bit here. But we're going to talk a little bit about all of that and how to make sure that you are able to preserve the record, able to preserve these juvenile specific issues while keeping with the theme of whatever your defense is. So first, just general preservations to-dos. Always, 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 always constitutionalize. If you can't think of anything else, I'm sure it's a due process violation. I have a cheat sheet I keep on my desk, and when I go to preserve, I pick that sheet up and go, Your Honor, just for the record, I'm making my motion on the blah, 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 blah. I'm going to show it to you in a second. And then you can't over-renew your objection enough, okay? Please, please, please renew your motion. Renew your objection, renew whatever it is that you need to renew. So if you have a pretrial motion to exclude evidence or to suppress evidence, you have to object when it comes in. If it comes in through multiple sources, object every time it comes in. There are times where you're going to have to object in order to properly preserve something. You might have to object to every single question in a line of questioning. And the way to do that without being obnoxious is to say, while the jury's out of the room, before that witness gets on the stand, Judge, I'm just letting you know, those appellate people, they tell me I have to object to every one of these questions. I'm so sorry. Please go blame Glenn Girding. Please go blame David Andrews. But what I'm going to do is I'm going to quietly say after every question, object on prior grounds, and look at the court reporter so she knows I said that. I don't need to be heard further. I understand the objection is going to be sustained, but I'm just going to say that quietly. And everybody can keep going, all right? And that way you're not interrupting the flow of the questioning and seeming very obnoxious to the jury by stopping every 10 seconds to object. But just know that you have to renew those objections. And if you forget, if the evidence comes in, do me a favor, and when you realize it, stand up and say, Your Honor, I am so sorry. I forgot to renew my objection when the evidence comes in. So I'm renewing it now. I'm asking you now that I am objecting to this thing coming in. I'm telling you I object to that. Please forgive me for not doing it at the time. It's never too late. This is the cheat sheet that I keep on my desk that I stole from Terry Alford. Where are you? So this is awesome. And it just gives you a quick cheat sheet of what the constitutional provisions are for each standard type of objection you might have. So you got the North Carolina Constitution and the United States constitutional provisions. So I'm going to start close to where they left off last time. They were telling you make sure that you challenge the transfer. When you do so in the juvenile, in the district court, in order to preserve it for the Court of Appeals, you have to appeal that. And it is an appeal that you do to the Superior Court. So you have to notice the appeal of the transfer decision in open court or within writing within 10 days of entry of the judgment transferring the case to Superior Court. And then you go to the Superior Court and you argue that it should not have been transferred. If you do not do this, the Court of Appeals is going to say, too bad, so sad, we don't care. Okay? So make sure that you get that taken care of if that is something that you have done in the lower court. And going back to Dr. Cottle's presentation, get an expert and get one early. You may not realize from day one where this expert is going to fit in your case. You may not think about or know the information to be able to tell, I'm going to have you talking about the voluntariness of my client's confession. I'm going to have you talking about diminished capacity. But you need that expert. There is going to be a way, a reason, a thing that you are going to do that is going to necessitate an expert. This is a murder case and it is a child and they are facing life without parole in prison. You want an expert. And like Dr. Cottle said, the earlier you get them, the better, the more contemporaneous, because children develop and they develop quickly. And so they're going to change very rapidly. And you want your expert to get a view of your child as close in time to the alleged crime as humanly possible. And frankly, when I have a juvenile murder case and I bring on an expert, I start by saying, I don't know yet. I just need you to go see him, okay? I just need you to go see him, just document their condition. Depending on how young they are, I might have at least some idea that they need a capacity determination. The younger they are, the more likely they are to need a capacity determination. But I'm going to need you at some point, so just go ahead and start writing down some impressions, and we'll move forward as we go along. This is very different than in my adult cases. I almost always have a mental health expert in my first-degree murder cases for adults, but I usually engage them when I've identified the specific issue I'm going to need them on, because I might pick different experts for different types of issues, right? But with children, it's just so important to get them seen soon. And I'm going to tell you, any forensic psychologist is going to be able to give you information about adolescent brain development and about the impact of an adolescent brain on their decision-making and on their crime and that type of thing. But there are definitely experts who have a higher level of expertise in this arena than other experts. And so, that psychologist that you use all the time in your adult murder cases may not be the best person to use for a juvenile case. So some experts that I've worked with, Dr. Cottle, she is sort of the preeminent expert in North Carolina on adolescent brain development. There's some others I've used Dr. Marianne Etheridge. She is great. She's really responsive. She's quick. And she's really great with kids. I have heard, though I have not used her for this purpose, that Dr. Jennifer Sapia is really, really good on adolescent brain development issues.
She's overbooked.
She's overbooked. She is overbooked. She is hard to get to move more quickly. That is accurate. But I have used her on several adult cases and have loved her work on those cases as well. And I say psychologist, you may need a psychiatrist too if there's special mental health issues, if there's other things going on. But what you need to start with is a psychologist. And I went through sort of the different ways that you might use the expert broadly, but we're going to talk a little bit more specifically as we go along in this presentation. So we're going to start with some motions and preserving the record for motions in a juvenile murder case. The first thing I put up here is 404B motions. 404B is admitted for these following purposes: to show motive, to show opportunity, to show intent, to show preparation, to show plan, knowledge, identity, or absence of mistake. And I want you to think about juveniles. How much does a juvenile plan? How much does a juvenile intend, prepare, right? This was written with the idea of adults in mind. And we apply it with the idea of adults in mind. But if you have a child and the state's saying some prior thing that they did shows their plan, shows their intent, shows those things, we've got to stop and adjust our idea about what that means for a juvenile. And I think you need to bring in adolescent brain development and your expert and your arguments about how those impact the judge's determination as to whether the 404B information should come in. So there's a lot of information that you can present to a judge to say that 404B, while it might come in for an adult, it shouldn't come in for a child. The other thing is, with 404B, we talk about temporal proximity between the prior event and the current event being one of the factors, right? Well, a year is not a very long time in the life of an adult, but it's a pretty long time in the life of a 12-year-old, right? So those are other ways that this is really impactful on this type of motion. Motions to preclude photos, videos, posts, etc. How many of your juveniles post an Instagram or a Snapchat video or where they say stupid stuff or they do stupid stuff, right? That's a lot of stuff in these cases. What I want you to think about when those things have some relevancy to your case is the balancing test the judge has to do under 403, right? How prejudicial is it, plus how relevant is it? Is it really as relevant as if an adult made the same video? Because a child wants to be in the mix. A child, right, like what does their development mean on how reliable that video is, how accurate that video is? Are they simply passing a rumor along, or do they actually have specified knowledge? Are they joining in a social media trend, right? Those things matter. Motions to suppress, I know we've talked about JDB and the reasonable child standard, but I want you to think about the reasonable child standard in other arenas. What is a child's expectation of privacy? You know, are they as aware of, say, the third-party doctrine and how that interferes with their right to privacy as an adult would be? You know, we talk about a reasonable expectation of privacy, but the case law about it is geared towards an adult's understanding of their privacy. How is being a juvenile going to affect that? Further, the custodial status of juveniles in other contexts, like say for seizure, you want to think about the reasonable juvenile, not the reasonable adult. I am a huge fan of filing pretrial motions on the constitutionality of LWOP and life with parole for juveniles, talking about, you know, we've seen this evolving trend getting juveniles to less and less time because of our growing understanding of adolescent brain development. It continues to grow. I think it is fair game to say we've learned more, and now life with parole should not be a punishment for juveniles. But it also allows you, from a trial strategy standpoint, to focus on something other than the horrible facts of your crime, and to focus on your client's mitigation. If you put together this motion about the child's background, experiences, the good things about the child, the things that make the child have hope, be redeemable, and you're putting all of this in a pretrial motion, and you're putting evidence on, and you've got Dr. Cottle on the stand talking about some of the amazing qualities of your client. Ultimately, if your client's found guilty of first-degree murder, this judge is going to decide whether they get life with parole or life without parole. And it's kind of akin to in a capital murder case when you front load mitigation. The more you talk about your client's adolescent status, your client's background and experience, the more you bring that out at every possible opportunity in front of that judge and then later in front of the jury, you're humanizing your client, you're creating that connectiveness, and you're preparing and laying a foundation for the judge to hopefully ultimately give your client the least possible sentence that they can. And I like anything that allows me to talk about something that's not the ugly facts in my case. So I do this pretrial motion sometimes. Now, in your trial, you want to present evidence of your client's adolescent brain development, okay? And there's several reasons for this. We're going to talk about other things that I want you to do and issues you want to preserve and issues you want to litigate for your client. And having that specific testimony is going to give you the basis to do those things, to ask for those instructions, to ask for the things that you want. But again, you're giving the jury context about who your client is and why they might be doing the things that they're doing. And I said the relevancy is always there because it is always there. The fact that your client is a child and operates as a child who may not be a child by the time you get to trial, who may not look like a child by the time you get to trial, it is really important to hammer home. We, as defense lawyers, we've been hearing for years about adolescent brain development, about how that changes the game for these children, about what that means in terms of their decision making. But somebody who is, operating a spreadsheet all day at a business and going home, that connection's not happening for them. They're not reading up on adolescent brain development science, and they're looking at the child sitting next to you who's now 19, 20 years old. And they're not connecting those dots. You need to connect them for them, right? And now we talked about a bunch of motions and trying to preclude videos and trying to preclude, you're going to lose those. All right, like, let's just be honest. You're going to lose that 404B motion. You're going to lose that motion to preclude that video. But when you have argued against those videos coming in because of your client's status as a juvenile, when you've argued against the 404B, when you've argued that motion to suppress, you now have a jumping off point to say, of course, my expert testimony is relevant because I have to explain the diminished value of that evidence. The same thing that I just argued in that motion is why the jury shouldn't take that confession seriously. It's why the jury should not read into that video the same way that they would for an adult, right? And so there's always some reasonable, relevant argument as to why a doctor's on the stand talking about adolescent brain development and your child's development is relevant to the case. And there aren't cases where this is not helpful. It is very, very helpful. So think through those issues, think through those ways, be prepared for the state to say it's not relevant if you're not arguing a diminished capacity defense. Be prepared with 10 arguments about why it is relevant. And if a judge says your expert cannot testify, you must do a proffer. Has anybody done a proffer of expert testimony before? See a couple hands. So a proffer is where you say, okay, judge, I hear you. You're not going to let me do it. But in order for the Court of Appeals to understand the possible impact this could have had, they have to know what would be said. So while that jury is at lunch, while we take a break or we end early one day, I need to put my expert on the stand and question them, as I would have in front of the jury, to create the record that the Court of Appeals needs to make this determination. Because if you simply say, all right, I lost that issue, I'm moving on, the Court of Appeals is probably just going to say, well, we don't know what they would have said. We don't know if it would be helpful. We can't decide this issue. So you must do a proffer. Most judges expect proffers, understand that they happen, they're fine with it. Some judges act a little testy and try to say, well, we'll do it another time, we'll do it. You gotta keep standing up and saying, my expert's busy. I gotta get them in here, judge. I gotta get them on the stand. They're available Thursday. Can we call court early that day so I can get this proffer? Don't shut up about the proffer, because a judge very well may try to run you out of time to do the proffer, okay? You gotta be annoying, you gotta be the squeaky wheel. Renew your objections. It's so important, I said it twice. I renewed my renewal of my objections, okay? So as you're going through trial, as those pieces of evidence are coming in, as those things are happening, renew, 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 renew. I use my own language. We had talked about the juvenile statutes and the language in juvenile statutes. I just like to think of them as options. It depends on the point I'm trying to make as to what word I use. I might use the word arrested rather than taking into secure custody, or I might use the word adjudicated instead of convicted. But depending on the point you're trying to make, you get choices of language to use. So, you know, if my client has prior adjudications coming in against them, we talk about adjudications. However, if I want to make the point that my kid was handcuffed and drugged into a jail, I say arrested, I say jail, okay? Think about the language that you're using, think about how it impacts the jury, and think about the foundation that you're laying, and remind everyone at all times that your child is a child. And I don't like juvenile, I like child. It is accurate, it is true. This person is a child. I love a nickname. If your kid, you know, if your kid is named, I'm trying to think about, you know, but if your kid's got, you know, the name Timothy, if he goes by Timmy, use Timmy and talk about him as a child. That emphasis, that reminder, it is going to go a long way in humanizing your client and in keeping this on the forefront of everybody's mind in the courtroom and in the Court of Appeals later on, that the fact that your client is a child changes literally everything. Charge conference. So this is where we get to get more creative again with the fact that our clients are children. I want you to think about literally every instruction. Is that this? Okay, well, I'm just gonna keep going. Think about literally every standard instruction and how you might want to potentially submit your own that has some sort of modification about how the jury should take into account your client's status as a juvenile. At first, if it's a bad instruction, you're just going to straight out object to it on the basis that it shouldn't apply to your child. But second, you're going to submit, and it must be in writing, your own special request for an instruction. And these are the ones that I kind of thought of. The concept of flight as consciousness of guilt, right? Our kids run away. I mean, my kids run away way more than my adults run away, right? And there's a reason for that. One, because they can be affected by things outside of a consciousness of guilt of a crime. Maybe they were out past their curfew. Maybe they broke their parents' rules. Maybe they're scared that the police are going to shoot them. There's a lot of reasons that a child might run away that have nothing to do with the consciousness of guilt of the crime that they're charged with. So you're going to want to object on those grounds. And then if it comes in, if they're going to do a flight instruction, think about how, and I'm going to give you an example of an intent later, but how to craft a special jury instruction that takes that evidence that you presented about your client's adolescent brain development and background and experience and incorporate it in a way that tells the jury they are allowed to take that into account in assessing whether or not that flight is something that they believe is evidence of your client's guilt. Intent or mens rea for whatever crimes you've got, that one is kind of the more obvious, right? We've talked about diminished capacity, but even if you don't have a straight out diminished capacity defense, if it's elemental and you're simply saying they, you know, that they need to take into consideration your client's age and development in assessing whether or not premeditation and deliberation occurred, that is something that is very, very relevant. The contradictory statements of a defendant, that really awful instruction. Again, we're talking about a child. Contradicting themselves can be a lot of things other than guilt. It can be even just their ability to specifically recall and regurgitate and give information over and over again. So those are three. I want you to sit down with every case, look at the possible instructions that are going to be read in your case, and think about how being a child could affect it. And then argue the heck out of why being a child should affect the jury instructions. I would love if you sat there with every single possible instruction down to reasonable doubt and came up with some way we've got to incorporate the fact that my kid's a kid, right? Any special instruction that you request must be in writing to preserve the issue, okay? You can't just stand up and ask for it. It can't be off the cuff. It has to be in writing. I'm going to show you an instruction. David Andrews was kind enough to share it. And it is a lot of words. I highlighted the part that is the most hyper-focused on adolescent brain development, but you can see that it's sort of woven in throughout the instruction. I'm not going to sit here and read it all, but I'll give you all a chance to look at it. I mean, this just makes sense. It just makes sense that, I mean, it's actually kind of crazy to think about the jury not taking special consideration of your child's status as a child into consideration in thinking about intent. I mean, we have children. We understand that they're impulsive, they are reactive, they don't always think through the consequences of their actions. That's intuitive in our everyday lives. But when we come into a courtroom, it's suddenly ignored. I want to talk for a few minutes about some particular issues I want you to think about litigating in juvenile murder cases. Self-defense, right? So I think there's a decent number of juvenile murders that I see where there's at least some self-defense element. But the same impulsivity that causes children and same reactivity that causes children to make poor decisions at times can also affect something is a threat. Something in front of them is a threat, right? And so I want you to think about, can you argue that a case that wouldn't look like self-defense for an adult is self-defense for a juvenile? There is some good case law, and they're talking about physical issues, but that says that the jury is supposed to put themselves in the shoes of the defendant with the including medical issues that a defendant has in assessing the reasonableness of the threat against them. If that's accurate, why are we not taking into account the juvenile's age and thinking of this as a reasonable juvenile standard for reasonable fear for safety, right? Similarly, I think that there could be arguments made about whether or not something's excessive force based off of some juvenile brain development science. These are things you need to think about well before trial because they may require specific testimony from your expert about this particular concept and this particular set of facts in this particular case, right? So make sure that you're thinking about this not a month before trial, but a year before trial, talking to your expert and developing this defense well in advance. But there is a lot of ways that self-defense is going to operate differently for juveniles. And obviously, all of these things matter. You might want to file motions about it. You might want to put special information in your notice of self-defense. You might want to ask for special jury instructions on self-defense. If the judge is going to give you self-defense instructions, ask for special jury instructions. Think through all the ways that you can advocate for your child in that role. Felony murder. Felony murder, their justification for felony murder is mainly deterrence and the idea that this is a reasonably foreseeable consequence of engaging in dangerous felonies, right? And I found a quote that really sums that up well. The rationale of felony murder rule is that one who commits a felony is a bad person with a bad state of mind, and he has caused a bad result, so that we shouldn't worry too much about the fact that the fatal result accomplished was quite different and a good deal worse than the bad result he intended. I mean, we're all defense attorneys. This is some hogwash for anybody, but it's particularly hogwash for juveniles, right? And our juvenile code, our constitutional law, everything out there tells us that we as a society do not believe this is true for juveniles. Juveniles are not bad people. Juveniles are not people that we don't care that they intended something different than they accomplished, right? If we're going to believe that, it is not going to be about juveniles. So, and I just sort of summed up the different things that we've talked about: deterrence, foreseeability, and a bad person. There's a lot of information out there, and your expert can give you this in trial if need be, or in a pretrial hearing, that deterrence is not a thing for juveniles. So that doesn't really apply to juveniles. The foreseeability, I mean, this is distant foreseeability, right? You go to rob somebody with a BB gun, you're not thinking about the possibility that things could go wrong and you could wrestle over the other guy's gun and somebody could drop dead, right? Like, those are not foreseeable for a juvenile. They're so attenuated. And certainly juveniles are not bad people. This is clearly something we don't believe as a legal system. So, file a motion to preclude the state from proceeding on any theory of felony murder, explaining all of this. put in an affidavit from your expert about the purposes of felony murder and why they don't apply to juveniles in general and your juvenile specifically. When the judge denies that, be prepared to have your expert talk about these things when they testify. Move to dismiss at close of state's evidence. Move to dismiss any felony murder theory on the grounds that it shouldn't apply to juveniles. Object to the felony murder instructions being given at all. Ask for special felony murder instructions that talk about these concepts and whether or not felony murder should apply to a juvenile. Why shouldn't a jury at least consider that? If the judge says no, we're not going to preclude it, why shouldn't a jury make the determination then as to whether or not this juvenile should be subjected to felony murder? And that's it. Yes, David.
I would just add one thing. You may make all of these requests for putting on evidence about adolescent brain science, jury instructions, and you might be denied across the board. But that doesn't mean when you get to closing argument that you can't argue common sense. Don't forget, you can just remind jurors that they're humans. They probably have kids, and they know that kids don't think like adults. Don't forget about closing argument as the last resort.
Totally agree. Don't forget closing argument like I did. Any other questions? All right. Well, with that, thank you.
David, I didn't know you were here. David, would you stand up for just a second? You guys, here's another name you've seen, and now here's the face. This is David Andrews.